From WDSU, News Channel 6 is on your side.
Welcome back, everybody. Right now in the French Quarter, Louisiana's top court is hearing arguments about two hurricane-related insurance cases. Now, the cases focus on what insurers are liable for when it comes to the levee breaches and wind versus water claims. For a little insight, we're joined now live at noon by attorney James Williams, a partner with Gauthier, Houghtaling and Williams. And Mr. Williams, it is good to see you today. Thank you for joining us. Let's talk, if we could, for a moment about what this means. First off, what is expected to happen today, and how long could this take at the Louisiana Supreme Court?
Well, today the Supreme Court is hearing the oral argument in the case, of course. After today, the Supreme Court roughly takes 6 weeks to issue arguments. However, everything in this case has been on an expedited basis, and so we expect that the Supreme Court will rule very soon, in a few weeks perhaps.
All right, so a few weeks from now we should know what happens. Let's talk about a couple scenarios here. The Supreme Court then says, yes, we favor Cher, of course Cher being the person who is suing a Lafayette insurance company for not covering their flood damage. What happens if they favor for Cher? What happens to the rest of us?
Well, if they favor Cher, which is what we homeowners and those of us lawyers who represent homeowners and business owners hope for, and that means that the insurance policies issued by the insurance companies are ambiguous in their description of what constitutes flood, and that the rising water that arose from the levee breach is covered by the homeowner policies. The homeowner policies in this state, the insurance companies crafted vague and ambiguous definitions of what is meant by the term flood. The plaintiffs, including Mr. Cher, have attacked that, and hopefully the Supreme Court will feel as we feel and as the Fourth Circuit Court of Appeal feels, which is that these exclusions are ambiguous, that they are not intended to cover a man-made flood caused by a levee breach.
So bottom line, after it's all said and done, if indeed that does come in favor of Mr. Cher, will we see more lawsuits like this?
We should hopefully see more lawsuits where homeowners and business owners can collect what they're truly owed under their policies, and the existing lawsuits should be improved greatly and dramatically for these people because they can finally recover the whole of what they have lost.
All right, so we have Mr. Cher on one hand. That is one of the cases that is being decided, being heard. Also, I understand there's something known as the valued policy law that basically, when you break it down, says, you know what, even if you got flood damage, it should be covered by an insurance company. That is being debated by those companies. Tell us exactly what their argument is.
Sure. The valued policy law simply states that where there are two causes of a loss and the property, the home in this case, is totally destroyed, then the homeowner insurer, the insurer that charged you a premium based on the total value of your home, should pay for the total loss. So if there is a wind loss and a flood loss, that because the premium was charged to you based on the whole value of your home, not part of the value, then the insurer is responsible for the total loss, and they should pay for the entire value of their policy because that's what you pay for.
All right, that's what that law says, but then you hear from groups like Citizens Insurance and other insurance, they say our policies cover damage from wind but not rising water. We deny that law. We do not think that that works. How do they go about saying that?
Well, I think it is unfortunately typical of what we've seen from the insurance companies in this state, trying to find a way not to compensate homeowners and business owners. They're trying to get away from the valued policy law, arguing that because their own insurance policy that they wrote somehow excludes flood. But these insurers should not be able to draft their way around a law that has existed in Louisiana for almost 100 years.
All right, it's hit civil court, it's hit circuit court, now of course at the Supreme Court. Some important decisions that's going to affect a lot of people. We thank you very much for joining us today, Mr. James Williams, a partner with Gauthier, Houghtaling and Williams. It's good to see you.
Thank you.